maximum post-survival period of
Right.
6 months.
Yeah.
It does do that.
Okay, across the board.
Across the board.
Okay.
Right. But again, as we pointed out when we were going through Batten and 1521, the real problem that is dealt with in Batten and that is dealt with in 1521 is not a prohibited substitution problem. It's a prohibited condition problem.
That's what I wanted.
Properly conceptualized. It's just the legislature didn't understand that, not surprisingly. Goodness, I'm going to give you slam on the legislature here on YouTube. I don't care anymore. I mean, it's just sloppy. It's terribly sloppy thinking. That is the problem was the limitation on alienability. There was no theoretical problem with prohibited substitutions there. But in any event, I think 1521 still has the effect of imposing effectively a limitation on the post-survival period of six months. So, look, let me make it real concrete for you. Let's suppose I draw up my testament today, and I say, I leave my property to you, Ms. Youngblood, fully vested in you now. However, if you don't survive me by 5 years, then it's going to belong to Ms. Fox. Is that a prohibited substitution? Hell no. There's nothing wrong with that. It's a double conditional legacy. That's not a prohibited substitution. But it might violate 1521. Yeah.
Is that all?
Yes, sir.
With regard to prohibited substitutions, to what degree of particularity do you have to not be?
The duty to preserve and render can be implied. And it would be implied simply, it would be implied in the following formula. I leave X in full ownership first to A and then to B. We always have understood that implies a duty to preserve and render.
Well, specifically with regards to who the duty to render is to, I think we had discussed in class where what the specific person, rather than class person, what.
That's correct. Yeah, the question that was asked in the back is, what about a double disposition of some kind in which there is a statement of a duty to preserve and render, but there's no indication of exactly to whom for whom the preserving has to be done and to whom the rendering has to be done. So, for example, I leave my house in full ownership to Mr. Scandrett, but upon his death, he shall preserve it until his death, and upon his death shall render it to Jack Weiss. Okay, well, that's a prohibited substitution. But now, I leave whatever it is to Scandrett, but he has a duty to preserve it, and at the end of his life to render it to a person of his choice. That is not a prohibited substitution. Does that mean it's not problematic? It doesn't mean it's not problematic, but it's not problematic under 1520. It's problematic. If it's problematic under which other article? 1519. So effectively, my imposing the duty on him to preserve it takes the property out of commerce. Mr. Hamilton?
One of the examples that we went over involving prohibited substitutions, I got the impression that sometimes the implied duty to preserve and render could be inferred from the nature of the item. For example, if it's consumable and you don't specify the duty to preserve, it would not imply it, because by reading the rules, obviously infrequent.
Yeah.
So, but
Certainly if it's me you're talking about in particular.
if it's like, say, immovable and there's no express speak to it, it's implied information.
That might be a fair way to put it. For those of you who are reviewing this at home, Mr. Hamilton suggested that perhaps the nature of the object of the donation has something to do with whether we would imply a duty to preserve and render. For example, a donation of consumable corporeal movables. It's hard to imagine that there would be an implied duty to preserve such a thing. But with a non-consumable, especially a non-consumable and movable, perhaps that would be an appropriate assumption to make, unless we're told otherwise. Okay. More questions? Ms. Fox?
When we talked about multiple legacies, we read this weird case, Hobson versus Radcliffe, that said that when you say to be divided between them equally, it creates a presumption of separateness unless you rebut that. Is there any other crazy language like that that we need to be aware of? Or what's separate and what's joint? Like everything else is pretty clear. If you just say, I leave my property to A and B, that's joint. If I say I leave my property to A and B, share and share alike, that's separate. If I say I leave my property to A and B to be divided between them equally, there's presumption of separateness that can be rebutted by other evidence.
That's correct.
And is there anything else is there any other language that's ambiguous like that?
Well, there's another example you should add to your list here. It's not a case event that we consider to be ambiguous, quite the contrary. I leave my horse to A and B in equal portions. Now that's understood to be separate, and that's an assignment of shares. But somehow changing the formula around to be divided between them equally raises some question and creates only a presumption of separateness. I've never thought it made a lick of sense either.
If you have if you assign shares or if you say in equal portions, but you put with the right of accretion, does that change that, or is that just when you say to be divided among them equally?
Ms. Colvin wants to know, I don't know where she's getting this idea from. Maybe an old exam. Sure, it's probably on yours too, because I like this. You have a nut. There are only two ways to explain this behavior, or three ways. Number one, you got somebody who's crazy. Number two, you got somebody who's ignorant. Number three, you got somebody who's being advised by a two-lane grad. One of those three, okay? And what does he do? He says, first of all, he starts out with using language that clearly indicates separateness. Let's just make it harder, Ms. Colvin. Let's just say this. I do hereby leave my horse to A and B separately, giving each only a half. Not joint. I loathe jointness. You're on a tear now. And then you say, and with right of accretion. Well, what the hell did you do? I don't know what you did. Because you used some language that was really clearly indicative of separateness. But then at the very end, you invoked a principle that plays only if it's joint. I can't reconstruct what you're thinking. We just give that to the trier of fact and say, what do you think? What do you think? Which thought pattern do you think predominates? Thought pattern that you see indicated in the first set of words, separateness, or the thought pattern you see indicated in the final set of words? Shh, I don't know how to deal with that. That's why I asked the question. Other questions? Mr. Scandrett?
Can I ask any questions about the Vivos donation?
The question for Mr. Scandrett has to do with donations inter vivos of negotiable instruments. He's worried about form. I don't blame him. It's confusing. You have in the big problem, which you can tell from the exam summary, the big problem in your exam is part 2, right? That's your big reduction problem. There is a disposition that involves some kind of commercial paper, and you'll have to tell me something about the form and whether the donation was successfully completed or not. All right, now that Scandrett knows it's going to be on there, he's got a real question, he says.
1550, does it really change the old law? It sounds like issuance is a
No, I don't think 1550 changes the old law at all. I think all that 1550 does is to make explicit what had not been stated explicitly in the Civil Code Articles on Donations inter vivos. I mean, there was no predecessor to 1550. 1550, I think, represents this and only this, and that is Max Nathan's attempt to alert the readers to the reality that there are more exceptions to the Authentic Act rule than the manual gift exception. Some of those exceptions have something to do with the law of negotiable instruments.